Welcome. In this session, we are going to learn about the meaning of negotiable instruments, different types of negotiable instruments, different types of crossing, duties of a paying banker, different types of endorsements, dishonor of negotiable instruments, noting and protesting of negotiable instruments. So let us try to first understand what is meant by a negotiable instruments. The word negotiable means transferable from one person to another, and the term instrument means any written document by which a right is created in favor of some person. Thus, the negotiable instrument is a document by which rights vested in a person can be transferred to another person in accordance with the provisions of Negotiable Instrument Act 1881. The main features of a negotiable instrument can be stated this way. It can be either by way of a statute or by way of usage. Statute means what has been mentioned in the Negotiable Instrument Act. Say promissory note, bills of exchange, checks are negotiable instruments under the Act. By usage, bank notes, drafts, share warrants, bearer debentures, dividend warrant, scripts, treasury bills, these are all negotiable by usage. Negotiable instrument can be defined as stated in the Act, but it merely states in section 13 of the Act that a negotiable instrument means a promissory note, bill of exchange or check payable either to order or to the bearer of the instrument. So it means an instrument may be negotiated by law or by custom. Presumptions relating to negotiable instruments have been mentioned in the Negotiable Instrument Act. Section 118 and 119 of the Act has certain presumptions. One, it shall be presumed that every negotiable instrument is drawn for consideration. So consideration is an important aspect. Every bill is accepted within a reasonable time before its maturity. This is the second thing. Third, the instruments are endorsed in order in which they appear on it. And finally, every holder is presumed to be a holder in due course. We will see a little later what is the meaning of a holder and a holder in due course. The instruments are classified in different ways. Number one, bearer instruments, that is instruments which are payable to the bearer. Order instruments, the instruments which are expressed to be payable to the order. Inland instruments, those instruments which are drawn and made in India upon any persons resident in India, even though payable in a foreign country. And then foreign instruments, those instruments not inland but maybe drawn outside India and made payable outside or inside India. Further, the instruments can also be classified as inchoate or incomplete instruments. When a person signs and delivers an instrument which is wholly blank or incomplete and gives the authority to make it complete to the holder, these instruments are called as inchoate or incomplete instruments. Then we also know there are accommodation bills. A bill drawn, accepted or endorsed without consideration. Party intending lending its name to oblige to the other party, accommodating or accommodation party. The party so obliged is called as party accommodated. Then we have trade bills. When a bill is drawn, accepted or endorsed for consideration, it is called as genuine trade bill. Escrow. When a negotiable instrument is delivered conditionally or for a special purpose as a collateral security or for safe custody only and not for transacting absolutely, it is called as escrow. Section 4 of the Negotiable Instrument Act talks about promissory notes. What is a promissory note? It's an instrument in writing, not being a bank note or a currency note. It contains an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instruments. So now we know that a promissory note requires two parties. One is called as a maker, another is called as a payee. Maker is one who makes or executes a note promising to pay the amount stated in the promissory note. Payee, the person to whom the amount is payable, is called as payee. To comply with other formalities also is important in respect of a promissory note. That means it should contain a date, the place should be mentioned in the promissory note, there should be consideration, and it should be adequately stamped. If a negotiable instrument is payable to bearer, it is negotiated by mere delivery. And if it is payable to order, it is negotiated by endorsement and delivery. A little later, we will see what is meant by endorsement. Section 5 of the Negotiable Instrument Act talks about bills of exchange. It is defined in the Act as an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So see, there are 2-3 things. Number one, it should be in writing, there should be unconditional order, it should be signed by the maker and directing a person to pay a certain sum of money. All these things are important to understand what is meant by a bill of exchange. Basically, it is an order to the creditor, of the creditor to the debtor to pay a certain sum of money to the person named therein. Now, there are parties to the bill of exchange. Who are they? One is drawer, the person who draws the bill. The second one is a drawee, the person on whom the bill is drawn. Then acceptor, a person who accepts the bill. Endorser, a person who endorses the bill in favor of another person. Endorsee, a person in whose favor the bill is endorsed. And normally the bills are drawn in set of 3, which are called as VIA, V-I-A. The whole set constitutes only one bill. Let us move forward and see what we understand by a check. Section 6 of the Negotiable Instruments Act defines a check as a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand. So a check is drawn on a specified banker. This is very, very important to be noted. And it includes electronic image of a truncated check and check in electronic form. We are going to understand these two terminologies a little later. So check is a bill of exchange with the difference that it is always drawn on a specified banker and it is payable only on demand. What do we mean by electronic check or a truncated check? Let us try to understand these two terminologies. A check in the electronic form means a check which contains the exact mirror image of a paper check and is generated and signed in a secure system with digital signature and asymmetric crypto system. A truncated check means a check which is truncated during the clearing either by the clearing house or by the bank paying or receiving payment. Checks are being crossed. What is meant by crossing of a check? If the drawer of the check wants to ensure safety and also wants to get an audit trail of payment, he may further direct the paying banker to pay the check only through the account of the payee. So crossing of the check fulfills the mandate of the drawer. Section 123 to 131 of Negotiable Instrument Act deals with the subject of crossing of the checks. These provisions are also applicable to banker checks, pay orders and drafts. What are the different types of crossing? Let us have a look at it. Section 123 and 124 deal with two types of crossing, that is general crossing and special crossing. What do we mean by general crossing? General crossing means drawing two parallel transverse lines across the face of a check. The crossing may include such words as "and company" or "not negotiable" in between the transverse parallel lines. The effect of general crossing of the check is that the same is to be paid only through a bank account only, and amount cannot be paid across the counter to the presenter of the check. Let us have a look at the specimen of general crossing. Here you find two transverse lines, and in between the words "and co, account payee, not negotiables" have been written. Let us try to understand what is meant by special crossing. If the check bears across its face, in addition to the crossing, the name of a banker, the check is deemed to have been crossed specially to that banker. The effect of crossing is that the proceeds of the check should be paid only to that banker. Because of this reason, the banks put crossing stamps on checks received by them for collection. Now, you can have a look at the specimen of special or restrictive crossing. You will find in each of these specimen the name of the bank is written. So that is what is meant by special crossing. Types of crossing: not negotiable crossing. What it means? This type of crossing would remove the negotiable characteristic of the instrument, and the transferee cannot have a better title than what the transfer had. Section 130 of the Negotiable Instrument Act states that a person taking a check crossed generally or specially, bearing in either case the words "not negotiable," shall not have and shall not be capable of giving a better title to the check than that which the person from whom he took it. So, not negotiable crossing means that the title which the person is going to get will not be a better one than the transfer had it. Account payee crossing. So, in order to add more protection to the check, sometimes the word like account payee or payee's account only are added to the crossing. This type of crossing has been provided for in the Negotiable Instrument Act. It has not been provided for in the Negotiable Instrument Act, but it is a practice widely followed. These words constitute a direction to the collecting bank to collect the proceeds in the payee's account only, and such instructions do not take away the characteristics of negotiability. The account payee crossing has not been provided for negotiable in the Negotiable Instrument Act, but it is a practice widely followed. Now let us have a look at one more point: whether a check can be crossed after it is issued. If the check is not crossed, the holder of the check may cross it either generally or specially. If the check is crossed generally, the holder may cross it specially also. The holder may add the words "not negotiable" to the crossing. What are the duties of the paying banker? Section 126 lays down the duty of paying banker, and this provision makes it obligatory on the part of the paying banker to pay the crossed checks only through a bank account. If he doesn't, the banker is going to be liable. When a check whose crossing has been opened, sometimes a client comes, cancels the crossing. That is called as opening of the crossing. When it is presented for cash payment over the counter, the banker will have to take certain precautions before making payment. What are those precautions? One, opening of crossing is authorized by the signatory of the check. Clear instructions should be there: crossing open, please pay cash, and the payment is made to the drawer of the check only and not to anyone else. And if a third party present by chance, then the drawer needs to be contacted to ascertain before making the payment that the person who has come and who is asking for payment is a genuine and he is the drawer's representative. And finally, if the check is not for big value, if it is for big value, fresh check should be called for. What is payment in due course is another important aspect which all of us must learn. Section 10 of the Negotiable Instrument Act lays down the conditions under which payment is said to be a payment in due course. What are the conditions which are required to understand this topic? Payment should be made in accordance with the apparent tenure, that is, what it appears on the face of the instrument. The payment should be made to the person in possession of the instrument. Where the instrument is made payable to a particular person or order, and if the instrument is not endorsed by him, payment to a person on actual possession of the instrument will not amount to a payment in due course. This point needs to be noted very carefully. There are occasions when banker must refuse payment. What are those points on which the banker should be very strict and can refuse and must refuse the payment? So they are, number one, where the customer gives stop payment instructions, that is, countermarks the payment. Number two, on receipt of notice of customer's death. Number three, on customer becoming insolvent. Number four, on receipt of a notice of the customer's insanity. Number five, on receipt of garnishee order. Number six, on assignment of credit balance. And number seven, on suspicious misuse by a trustee. Let us move forward and try to understand some more terminologies. What is meant by endorsement? Section 15 of the Negotiable Instrument Act defines endorsement, which means signing on the reverse of the instruments or even on a piece of paper called a loange for the purpose of negotiating the negotiable instrument. If the endorser signs only his name without adding any instructions or directions, the endorsement is called as blank endorsement. This is mentioned in section 16(1) of the Negotiable Instrument Act. What are the different kinds of endorsement? Endorsement in blank, which you have already seen, that if there is only name of the endorser payable to the bearer. Special endorsement or endorsement in full, if it is made to a specified person, it is called as endorsement in full. Sans recourse endorsement, it excludes his personal liability by limiting the liability. Conditional endorsement, if a condition is specified by the endorser, it is called as conditional endorsement. Restrictive endorsement means if it is specified to one person only, it is called as restrictive endorsement. Facultative endorsement, if the provisions of giving notice of dishonor is waived, it is called as facultative endorsement. Here are the specimen of endorsement. On the left side you see blank endorsement, and on the right side you see special endorsement where the name of a person has been specified. Let us also try to understand what is meant by holder. This has been mentioned in section 8 of the Negotiable Instrument Act. A person who is entitled to hold a negotiable instrument in his own name, to possess the instrument and to recover or receive its amount due from the parties is called as a holder. To be a holder, a person must be named in the instrument as payee or the endorsee, or it should be bearer thereof. What is meant by holder in due course? If a person proves that he acquired the instrument for a valuable consideration, then he is known as holder in due course. The holder in due course should show that for consideration he became the payee or endorsee of the instrument if it is payable to the order. In such cases, the instrument should have been endorsed and delivered to him, as his title to instrument will be incomplete without delivery. What are the responsibilities of a paying banker? This is an important point which all bankers must know. Under section 31, banker is under obligation to honor the customer check subject to certain conditions. In order that the drawee bank executes his customer's mandate, the customer should observe reasonable care in drawing the checks. So what are the points which a banker should look at? Number one, the check should bear a date. The mandate of the customer should be clear as to whom the money is to be paid. The amount of the check should be written in words and figures at the space provided for it. The drawer's signature should be as per the specimen kept on the bank's record. So the banker has to obviously see all these points and then make the payment. Protection to the banker as well as banks under the check truncation system. All of us know that the Reserve Bank of India has given instructions for check truncation system, and check should be in the CTS format. So here, in order to protect the banker as well as the customer, certain guidelines have been given. What are those guidelines? Let us have a look at it. So no changes or corrections can be carried out on the checks other than for the date validation purpose if required. For any change in page name, amount in figures, amount in words, fresh check leaves need to be used by the customers. So any cancellations are there, those checks cannot be honored by the bankers. This would help the banks in identifying and controlling the fraudulent alterations. Let us now have a look at the responsibilities of a collecting bank. The collecting banker plays a dual role as paying banker and collecting banker. Section 131 of the Negotiable Instrument Acts provides for protection to a banker receiving payment of a check under certain conditions. The collecting banker should receive payment for a customer. Protection under section 131 is available only to the cross checks, and as such, crossing should be done before the banker accepts the check for collection. The protection is available only when the collecting banker receives a payment for his customer and not for non-customers. This is also one of the important points which should be noted. Instances where the collecting banker may be held responsible are quite a few. Number one, collecting a check payable to the company or a trust in private account of the director or a trustee. The banker can be held responsible. Collecting checks for very large sums in an account which has otherwise low operations. So the banker may be questioned. Collecting checks payable to the order without verifying the endorsements. Then collecting the check crossed account payee in an account other than the payee, the banker can be held responsible. Collecting the check in an account which is not properly introduced, so the banker doesn't get protection. Collecting the check in a third party's account without proper precautions. So these are the points where the banker can be held responsible, and the banker should be aware of these points before collecting the check. Now, instruments are sometimes dishonored. What is meant by dishonor of a negotiable instrument? Dishonor of a negotiable instrument happens due to non-acceptance of the bill or non-payment of the instrument. Dishonor by non-payment happens when the maker, drawee of the check or acceptor of the bill makes a default in payment upon being duly required to pay the same. It is considered to be dishonored by non-payment when the presentment for payment is excused and the overdue amount remains unpaid. Dishonor by non-acceptance happens in the following ways. Number one, when the drawee does not accept within 48 hours of the presentment. Number two, when the presentment for acceptance is excused and the bill remains unaccepted. Number three, when the drawee is incompetent. Number four, when the acceptance by the drawee is qualified. Number 5, when the drawee is fictitious person or cannot be found after reasonable search. So in all these such cases, a notice of dishonor is a must to all prior parties whom the holder wants to make liable, except in those cases where the law considers it as unnecessary. Noting and protest. What is this noting and protest? It is the process of recording dishonor by the notary public upon the instrument within a reasonable time of dishonor. It is the discretion of the holder to get it noted or not. A bill that is noted must contain the facts of the dishonor, the date and the reasons. It will also have the notary charges. When the process of noting is certified, it is called as protest. In case of dishonor of check, which is covered in section 138 to 142 of the Negotiable Instrument Act, it provides for criminal penalties in the event of dishonor of checks for insufficiency of funds. The drawer of the check, if the check is dishonored, may be punished under section 138 with imprisonment for a maximum period of 2 years, and this has been done after the amendment which was passed in the year 2002. He may be imprisoned or he may be fined, which may extend to twice the amount of the check or with both. It all depends upon the view taken by the judge. The amendment has inserted 5 new sections, section 143 to 147, for the procedure to be followed for trial. What are the conditions to attract criminal penalty under section 138? Let's have a look at it. The check is dishonored due to insufficiency of funds. The payment for which the check was issued was for discharge of a legally enforceable debt or a liability in whole or in part. So if it is a gift, then the liability will not arise. So in that case, section 138 will not be applicable. The check has to be presented to the paying bank within 3 months from the date of its drawn. The payee should have been given a notice of dishonor of the check. The drawer will be liable only if he fails to make the payment within the notice period. The payee of the check should have made it a written complaint within 1 month of the cause of action. So once these things are followed, a trial can be filed in a criminal court, and depending on the case and depending on the amount, the judge will take a view about the action or the fine which is to be imposed. Thank you very much.